Welcome to Breaking Ties, Is Divorce the Answer? This is your go-to source for practical advice and support when considering if a divorce is the right answer for you. Join us each weekday for a quick chat where we'll uncover a variety of topics such as child custody, property division, and self-care. Together, we'll explore the emotional, financial, and legal aspects of divorce and help you find the best path forward for you and your family. Here is your host and Certified Divorce Financial Analyst professional, Mike Fulkerson.
Hello, and welcome to the Breaking Ties, Is Divorce the Answer podcast, where we discuss all things to think about when considering getting a divorce. Today's topic, we'll be talking about child support and what it entails when going through a divorce. So, first and foremost, what is child support? Child support is a court-ordered payment made by one parent to the other for financial support of their minor children. This includes such things as food, clothing, housing, and medical expenses. The primary goal of child support is to ensure that the children maintain a standard of living similar to that of both parents, even after the parents have separated. And really, this is going to keep the best interest of the kids in mind. So you want to make sure it's done properly and that they get the proper support that they're entitled to. How is it calculated? So child support is calculated based on a variety of factors, including the income of both parents, the number of children there are, the amount of time each parent spends with the children, and any special needs the children may have. The calculation is typically done using a state-specific guideline, which takes into account the aforementioned factors to determine a fair and reasonable amount of support. It's important to take a look and understand how the child support calculation takes place so that you have a better understanding of the numbers that'll be involved. Now, what happens if the paying parent doesn't make payments? If the paying parent fails to make child support payments, the recipient parent can take legal action to enforce the court order. This can include wage garnishment, seizure of property or tax refunds, or even jail time for contempt of court. It's important for both parents to understand the serious consequences of not following the court's order for child support. Can child support change due to change in circumstances? Circumstances can change, and if either parent experiences a significant change in income or other factors that affect their ability to pay or receive child support, they can ask the court to modify the support order. It's important to keep the court informed of any changes in circumstances so that the support order can be updated accordingly. So that's an overview of child support and what goes into it. I want to thank you for watching today's episode of Breaking Ties, Is Divorce the Answer? We hope that this has provided valuable information on child support and what to expect a little bit going through a divorce process. Remember that divorce is not going to be the end of your story. It is the start of your next great chapter. Until next time, take care. Hello, and welcome to another episode of Breaking Ties, Is Divorce the Answer? I'm your host, Mike Fulkerson, and in today's episode, we will be discussing the ins and outs of common law marriages, including which states recognize them and what you need to know about getting a divorce. We probably should start with kind of like what the definition of a common law marriage is. And a common law marriage, also known as an informal marriage, is a type of marriage recognized in a limited number of jurisdictions. It occurs when two people live together and hold themselves out as being married without actually getting a marriage license or having a formal ceremony. So you're kind of like married without being married. Now, you may actually be surprised at the number of states that recognize common law marriages. Currently, there are only 9 states that still recognize common law marriage. Those are Alabama, Colorado, Iowa, Kansas, Montana, Oklahoma, Rhode Island, South Carolina, and Texas. However, even within these states, there are requirements that must be met in order to establish a common law marriage. You will want to review your state laws should you decide to move on with the divorce process to make sure first you qualify for a common law marriage that you can get divorced from. Now, how does one dissolve a common law marriage when you didn't have a ceremony, you don't have a marriage license, you didn't go through all the hoopla? Well, if you're in a common law marriage and want to dissolve the relationship, you'll actually need to go through a divorce. The process for getting a divorce in a common law marriage is similar to the process of one for a formal marriage. You'll need to file for divorce and go through the court process to divide property and settle any other outstanding issues, just like a regular divorce. In conclusion, common law marriage is a type of marriage recognized in only 9 states in the United States. If you're in a common law marriage and you want to end the relationship, you'll need to go through a divorce, just as if someone had a marriage license. It is important to understand the laws and requirements in your state if you're considering entering into a common law marriage, so that you know in the future what your options are. I want to thank you for tuning in to today's episode of Breaking Ties, Is Divorce the Answer? I hope this information provides you a better understanding of common law marriages and actually getting divorced from them when it's not really a formal process. But the divorce process is formal when dissolving the relationship. Should you have any questions, feel free to reach out to me. My contact information is in the description. And join us next time for another informative episode. Keep in mind that divorce is not the end of your story. It is the start of your next great chapter. See you next time. Welcome back to the Breaking Ties, Is Divorce the Answer podcast, where we explore the different aspects of considering divorce. Today, we'll be discussing a sensitive topic that affects not only the human partners, but also the furry ones when a couple gets divorced. We're going to go over what happens to pets. As we all know, divorce is a very difficult and emotional process. It's just draining. And that's not only for the human partners involved, but also for our pets. Pets are often considered as family members and are deeply loved by their owners. During a divorce, the issue of pet custody can become a source of conflict between the separating partners, and it does happen. In most states, though, pets are considered property and are subject to property division laws. This means that the pet may be considered as a marital asset and divided between the separating partners, just like any other piece of property. However, this approach does not take into account the best interest of the pet and the emotional bond between the pet and its owners. To address this issue, some states have started to adopt pet custody laws that recognize pets as more than just property. These laws are considered the best interest of the pet and try to ensure that it goes to the owner who can provide the best care and environment for it. In these cases, the court will consider factors such as who has been the primary caregiver of that pet, who has better living situation for the pet, and who has a closer bond with the pet. In conclusion, the issue of pet custody during a divorce can be complex and emotional, just like the divorce itself. It is important for separating partners to be aware of their state's laws and consider the best interest of the pet in any decision-making process. When possible, it's always better for the partners to come to an agreement on their own rather than leaving the decision up to the court. Pets are not just property. They are members of our families, and we have a responsibility to ensure their well-being. That's it for today's episode of Breaking Ties, Is Divorce the Answer podcast. I hope you found this discussion informative and helpful. If you have any questions, feel free to reach out to me. My contact information is in the description. And remember that divorce is not the end of your story. It is the start of your next great chapter. Until next time, take care of yourself and your furry friends. Hello, and welcome to this episode of Breaking Ties. Is divorce the answer? Today, we're discussing an important and sensitive topic, getting divorced in your state and knowing the state laws. Going through a divorce is very difficult already and challenging emotionally, but it's also a legal process that requires a solid understanding of the state laws that pertain to you. Every state has their own system, has their own rules for determining child support, spousal maintenance, visitation, moving. And so it's important to keep on top of these and know what your rights are as a divorcee. And not to forget that part of it is the states will change these laws or adjust them from time to time. So what's good this year may not necessarily be good next year. Now, where do we start? I mean, there's a vast amount of knowledge, and as you and I know, the legal readings and laws usually aren't entertaining or a whole lot of fun. It's a bit dry, put you to sleep kind of situation. So where do we find this information? Well, first, and probably the most obvious place would be consulting an attorney. And an attorney will provide you with personal advice on the state laws that are specific to your situation, and also the procedures and processes and how the whole legal process works for the divorce. In addition to consulting an attorney, you can also start by researching the divorce laws in your state. You can do this online. Most of the time, there's websites, official websites through the state that will actually list the laws and start you on the process of understanding what they are. You can also visit the local courthouse and request information on divorce proceedings in your state. Many courthouses have informational packets that are available to the public, or they might be able to email them to you in a PDF. And that might be a good starting point and give you a better understanding of the legal process. Another resource you can use is online forums and support groups. There's a lot of online communities out there, and there's a lot that are dedicated to divorce, and it just gets narrowed down by states and communities and such to help individuals navigate going through a divorce. And they're also a great way to connect with others who have gone through the process and provide you with valuable insights and information. So let's keep in mind that divorce laws can vary from state to state, and it's critical to understand the laws for your state. What worked for my state, doesn't necessarily work for your state if you live in a different state. There might be some overlap. There might not be. And also, what we want to keep in mind that divorce proceedings are influenced by factors such as income, the number of assets you have, and children involved. In conclusion, learning about your state laws and procedures when getting a divorce is an important step in the process. By consulting an attorney, researching laws in your state, visiting the local courthouse, and connecting with online communities, you can ensure that you have the information and support you need to navigate the legal system with more confidence than when you started. I want to thank you for tuning into this episode of Breaking Ties Is Divorce the Answer? Join us again next time for more information and discussions on navigating the divorce process. And just remember that divorce is not the end of your story. It is the start of your next great chapter. Take care. Hi, and welcome to the Breaking Ties Is Divorce the Answer podcast. Today, we're discussing the financial affidavit in divorce proceedings. This document is actually crucial to the divorce process and the part it provides because it's an overview of the financial situation of both parties involved. Now, let's look at the financial affidavit and what exactly is it? It's really just a declaration written of each party's financial status. It provides a comprehensive overview of the party's assets, liabilities, income, expenses, and any other financial information that needs to be disclosed. The purpose of the financial affidavit is to provide a clear picture of each party's financial situation to the court so that a fair and just settlement can be reached. Now, there's a lot of information that's included, and so let's look at a few of these items here. A financial affidavit is typically going to include things like assets such as real estate, bank accounts, stocks, and personal property. Also liabilities such as any mortgages, credit card debts, or any other loans you may have. Income from all sources, including salaries, bonuses, rental income, and any other miscellaneous income. And it'll include expenses, including housing, food, transportation, and entertainment. It is important that the information on the financial affidavit is accurate and up to date, as it forms the basis of the court's decisions. You don't want anything left off, and you don't want to add anything extra to be included. So making sure that it has everything that's relevant is what the important part is. So why is the financial affidavit important in divorce proceedings? The financial affidavit provides information to the court to help them make informed decisions regarding property division, spousal maintenance, and child support. It allows the court to see the financial situation of each party and ensure that the settlement reached is fair and equitable. And if you've listened to other podcasts, you're going to know that fair doesn't mean 50-50. Fair is whatever worked out for both parties. So fair is not equal when it comes to the settlement agreement. In addition, having a clear and accurate picture of the financial situation of both parties can also help speed up the divorce process. Taking less time means less attorney costs, which actually does save you money. And when both parties agree on the information in the financial affidavit, there is less room for negotiation and disputes, which that allows the process to move a little more quickly. Now, there are times, you look at and go, well, what if one party doesn't provide accurate information in the financial affidavit? Providing false information in the financial affidavit it's a real serious matter. If a party is found to have provided false information, they could face serious legal consequences, including fines and even imprisonment. It's not taken lightly. Additionally, if the court relies on false information in reaching its decision, the settlement reached may not be fair and just. This can lead to further disputes and the need for the case to be reopened, which can result in additional costs and delays. And we really don't want that. Once we finalize the divorce, we would really like to move on. And that's what we have in a nutshell for the financial affidavit in today's episode. I want to thank you for joining me on Breaking Ties, Is Divorce the Answer? I hope you found the information helpful. And if you have any further questions, my contact information is in the description of the podcast. Remember that divorce is not the end of your story. It is the start of your next great chapter. And I'd like to thank you for listening and have yourself a good day.
We want to thank you for listening to this episode of Breaking Ties, Is Divorce the Answer? With Mike Fulkerson. For questions, please reach out to Mike via email in the description or give him a shout at 630-444-1410. And remember to subscribe, like, and follow.